Non-traditional relationships. Well, that's the title that's used by the board. I would say with the relationships we're going to talk about have been around a long time, be it divorce, which goes back, I would guess, probably 2,000 years or more in the Western culture, as well as uh, raising adoption of children, which certainly goes back a long time too, goes back at least to the Roman era. But I would say it's non-traditional from the standpoint of what financial planners have been concerned with over the years. And so that's why I think it's called a non-traditional relationship. Uh, but it's certainly been around for a while. And the problems we're going to discuss really aren't new either. Uh, they go back centuries. Non-traditional relationships are becoming the norm. And I say that because as we read the papers today, we find out that in many cases, um, children are born out of wedlock are becoming the norm, not the exception. And we also find that divorce couples are becoming more norm, and people who never get married are becoming more and more normal. And if we have children, we have it later in life, so that yes, indeed, it's different than what we've been covering in financial planning in the past, certainly under the CFP program. Um, I might note that also that you need more training in these areas than we offer by this course. The board still is trying to, in my mind, again, this is my opinion, still trying to figure out how much they should get into this area of what they call non-traditional relationship, and they're concerned, I think, about being politically correct and everything else associated with that. So, if you are going to be dealing with these types of things, relationships, that you should be obviously getting more training offered by the board. There are local social centers offering it, junior colleges offer it, etc. Um, First, let's start off with children from another relationship. You either had children out of wedlock, or you had children who you had from a former marriage, and you're concerned about avoiding disinheritance, which is a big problem here in California and the community property states, because the community property assets are controlled by both spouses together. So if you have all your assets being in community property status, it becomes very difficult to give funds at death to children from another relationship, because you don't really have any independent funds. Um, and you need permission of the spouse during lifetime. So at death, what do we do to take care of it at death when we finally do get control? Well, we can establish a trust that takes effect at death. We can use the Q-tip, which we also discussed in this course. We can do a series of lifetime gifting, but that requires the permission of the spouse. Again, we're talking about community property states. We can place assets into a joint tenants' rights to survivorship. Again, that would require this permission of your spouse if these were community property. And we can include them in a will, which obviously makes sense. Now, um, if you're not in a community property state, of course, it's a lot easier. The common law states allow you to use your funds, so your funds can be used for any of these purposes, and you don't have to worry about getting the spouse's permission in most cases. Again, all of these you can see are basically should be thought out either dealing with a lawyer or with a financial planner. For example, lifetime gifting is something that a financial planner can work out with the client, but setting up a will or a Q-tip will require a lawyer, obviously. Impacts of divorce. I think I heard once that half the people in this country, half the marriages in the country would line up in divorces. And if you're divorced at least once and you get married again, at least two-thirds of the second marriages also wind up in divorce. So divorce seems to be very prevalent in this country. Um, and the problem we're concerned with in financial planning is that the will that was written many years ago and was lovey-lovey time, and after divorce isn't changed, that those assets may still go to that spouse that was called out in that will that was never changed. And therefore, that can be an embarrassment as well as a problem because you're not taking care of your current family. In some states, by definition, at death, and the former spouse did not get assets from the deceased. In other states, they can. So you're going to have to, quite honestly, find out what the rules are in the state where your clients are domiciled. And I think the best thing to do is always add a divorce or a remarriage. Always update your wills and all your documents. That unfortunately people don't. That's why it becomes necessary for you to get involved here to make sure that the will has the right person in it. More than once, I've had people come to my office and say they had a will, and yes, indeed, it was up to date. And when we looked at the will, it was not up to date. So again, you got to see the will. Um, and obviously, when you get divorced, you should remove spouse from all legal documents, registrations, and titles. A lot of people assume the attorney's doing that for them, and the attorney isn't. That is really going to be, and I think for most people, either your accountant or your financial planner. And I think the financial planner is probably best able to do those re-registrations. It's sort of like setting up a trust. The lawyer sets up a trust, but when you want to put assets in it, you're going to need a financial planner or some other expert to do that for you. And clients don't understand that. They think, well, they got a trust, that's all they had to do, or they had a will set up one time, that's all they had to do. And I think financial planners give a big help to their clients by reminding them of the need to update this stuff. Guarantee of child support and alimony. I think if you've been involved in people dealing with problems getting child support and alimony, you know what I'm talking about when I say this is a terrible area to get involved in. I do pro bono work, and quite honestly, I see so many cases of women, in some cases men, who are raising children without any income coming in from the other parent. And a lot of it could be solved at the time of the divorce, if there was a divorce involved. I would say about a third of my situation I'm dealing with is the people were never married, so it's very difficult to get any type of support unless you get a DNA test, and people don't volunteer for that. So let's talk about really what's can be done, which isn't a lot. One is you can have an irrevocable trust set up. That would be done if, for example, in a divorce court case, that's where you typically set it up. Or if there was people were not married, and so there's no divorce, but they're breaking up, and the lawyers managed to reach an agreement on settling the assets between the two parties, and they agreed to set up an irrevocable trust to provide the child support and or alimony. Custodial accounts, another thing that has to be set up, and that again requires an attorney, and that requires again the person voluntarily doing it, as opposed to courts. And then we have conservatorships where the court sets it up. Again, none of these are easy, and none of these, in my opinion, are the real answer for the problems in society today, where we have so few payments of child support and alimony. But that's probably inherent in the society we have today. Cohabitation, again, probably more cohabitation cases today than there are marriages in this country. Certainly, if it isn't already that way, it's going to be relatively soon. Efforts have to be addressed. First of all, there's not going to be any marital deduction for the parties, so that can be a disadvantage. Also, they cannot do a joint tax return, so that can also cost them some money in taxes. We have to worry about the liquidity at the first to die, so there should be a life insurance policy in place. Wills should be included to cover specific bequests for the survivor. And we find that in some states, and some counties, where if you have general bequests for a cohabitant, it is looked down on against public policy. So therefore, they require specific requests. It's just a general idea, good idea to have specific requests called out. Revocable trust is something else we can use. And finally, gifting during lifetime. Although, again, if you go back to what we talked about gifting being irrevocable, there are very few cases you should do it. And maybe if there's a health issue involved, would justify it. But generally, gifting should be restricted to, again, need to support a family member, need to support a charity, assets that are such that they're difficult to come up with a valuation for estate tax purposes, so we like to get rid of them before death. And then finally, if we're just trying to reduce our estate. Adopted children, they are always able to adopt from their adoptive parents, and so they're able to inherit from their adopted parents. In many states, they cannot be an heir from natural parents, which is a shame because sometimes the natural parents did want to give up the children, but because of circumstances they had to. We now also have open adoptions in this country, which are becoming extremely popular, where the adopted children keep in touch with their natural parents and grandparents. I have 3 grandchildren who are adopted, and they all keep in touch with at least their grandparents, not necessarily their parents from their natural parents' side. And natural grandparents are including them in their wills, but they cannot be an heir. An heir means probate. Instructions of natural adoptive parents should be explicitly stated in their wills. And again, this is so important, having an attorney aware of the fact these are adopted children, or that you want to give to children that were adopted by somebody else. And I saw this again in the wills of the one grandparent of my natural grandparent of my grandchildren. And it's got to be very clearly stated, and there's certain wording that the lawyers are required to use, depending again on the state. So that's the topic we kept in mind. Again, these areas are not new. They're new to financial planning, and these are all areas that we don't really have any good answers on yet today. And certainly, if you want to deal in that area, it's an area of expertise in itself. I know several social workers who specialize in this area who do financial planning also, and would like to become financial planners full-time, but they just can't get away from the need of helping people in these situations. Well, we've completed Module 2.